Let's fill out a North Dakota prenuptial agreement together and check off every legal requirement as we go. This is North Dakota's prenuptial agreement, the contract a couple signs before marrying to set their own financial rules. On the right is everything North Dakota asks of it. This is a contract between two people planning to marry, made ahead of the marriage and effective when it happens. A marital agreement is the version for spouses who plan to stay married, affirming, changing, or waiving a marital right or duty. The act does not reach every agreement ever signed in the state. The statute names the date it starts from. The agreement has to be in writing, and that is the document in front of you. Start with the effective date, the day the couple plans to sign before their wedding. Type the month, day, and year here. Signing does not switch it on, it takes effect when the marriage happens. This one takes effect when both sign it, not on a marriage. If the marriage turns out to be void, the agreement holds only as far as needed to avoid an unfair result. The clock on any claim under the agreement is paused while the couple stays married. Next, enter each prospective spouse's name and mailing address, exactly as they will appear on the signed pages. The agreement calls them Prospective Spouse 1 and Prospective Spouse 2, names carried through the signature block and the schedules ahead. Neither person owes the other any payment or promise for this to hold. The marriage itself is the exchange. Each person has to sign it of their own free will. An agreement someone did not sign voluntarily does not hold against them. If the agreement is challenged, state law looks at whether each person had access to their own lawyer, as it defines that access. Further down, a clause names which state's law governs the agreement and which state's courts would hear a dispute. This is a North Dakota agreement, so both blanks say North Dakota. It can name another jurisdiction's law, if that place has a significant relationship to the agreement or to one of them, and its law does not offend a fundamental public policy here. This chapter sits with the Federal E-Sign Act, modifying and superseding it except where the statute keeps it. The attached schedule lists each person's finances. Spouse 1's copy shows a bank account, a car, and some jewelry as examples. State law sets how each person discloses what they own and owe, and what happens to the agreement if they do not. That disclosure can be waived only if the person does it voluntarily and expressly in writing. Spouse 2's copy follows the identical layout, with a different sample balance, vehicle, and valuable item. A support waiver cannot push someone onto public assistance. A court can order support to the extent needed to avoid that. The agreement closes with a signature line and a dated line for each spouse. Both people have to sign it, so neither page stands alone. The court decides whether the agreement is unconscionable, and it decides it as a question of law. It cannot touch a child's right to support. The couple cannot sign that away or trim it. A term that limits a remedy state law, gives a victim of domestic violence, is not enforceable. A term that tries to change the ground state law, gives for a separation or a divorce, is not enforceable. A term that penalizes a person for starting a separation or divorce case is not enforceable. A term about who cares for a child does not bind the court. Fill out your own prenuptial agreement free at FormsPal, no sign-up required.